In this second part to our two-part webinar series on international arbitration, I will discuss the practical side to arbitrations, which will include your arbitration agreement and things for you to think about, benefits of different institutional rules, interim remedies in arbitration, and enforcing your award. Let us start by looking at your arbitration agreement. In our seminar on an introduction to international arbitration, my colleague Anna Braden highlighted what arbitration is and the key features of arbitration. One of the cornerstone principles of arbitration is that you can agree how to resolve your disputes. Parties can set out the arbitration agreement in a clause in the contract, which is often the case, or sometimes have a standalone agreement. Although arbitration agreements are embedded in the parties' contract, they are treated as separate to the main agreement. This is what is known as the doctrine of separability. Now, this simply means that regardless of whether or not your main agreement is terminated, the arbitration agreement remains valid and binding on the parties. When looking at arbitration agreements, do not copy-paste an arbitration agreement from one contract to another. This is unhelpful and risky because there is no such thing as a standard contract or a standard dispute. Instead, parties should look at the particular circumstances, such as the nature and value of potential claims, the complexity of potential claims, the speed with which a decision is required, the location of the relevant parties, and for the purposes of enforcement, the location of their assets, the language, the seat of arbitration, the number of arbitrators, and any preconditions to arbitration, such as mediation. Now, the first question, therefore, to ask yourself is whether arbitration is suitable for the kind of disputes envisaged under the contract, considering the laws affecting the parties. Not every dispute is arbitrable. Different states, in accordance with their own social, political, and economic policy, decide which matters may be fit for arbitration and those which remain in the domain of local courts or other special tribunals. For example, in a case related to one of Europe's worst oil spills by the Prestige, the English Commercial Court gave examples of what the arbitrator cannot do. For example, he cannot impose a fine or a term of imprisonment or make an award which is binding on third parties or affects the public at large, such as a divorce decree or a winding up order. In certain common law jurisdictions, where previously certain disputes were prohibited for public policy reasons from being arbitrated, these can now be arbitrated where the parties agree. So examples include shareholder disputes and claims for compensation for unfair prejudice in the conduct of company affairs, disputes arising from intellectual property licensing agreements, disputes which were subject to regulatory and/or criminal sanction, including anti-competitive transactions. Looking closer to home, under the UAE law, disputes involving labor law cannot be arbitrated. Likewise, only UAE courts can hear disputes arising between a principal and an agent regarding a commercial agency agreement. Criminal matters, family law matters, and public policy matters cannot be the subject of arbitration. Under the UAE Civil Code, public policy matters include matters relating to personal status, such as marriage, inheritance, freedom of trade, and other rules and foundations which should not conflict with the fundamental principles of Sharia law. You may also want to consider the contract amount and the value of potential claims. For large multi-million commercial or construction contracts, arbitration is often preferred because of the expected complexity of the subject matter. Alternatively, for a small value supply of labor or materials contracts in the UAE, it might be better to have the Dubai courts as the choice of forum, or even the DIFC courts because of their small claims tribunal. The small claims tribunal of the DIFC courts hears disputes where the claim amount does not exceed 500,000 dirhams, or where the parties agree in their contract to refer their claims to the small claims tribunal, it can hear a claim not exceeding 1 million dirhams. Your aim when drafting your arbitration agreement is to avoid pathologies and ensure the enforceability and operability of your arbitration agreement. We often see in construction contracts that arbitration agreements are drafted by project managers or someone from the commercial team instead of in-house lawyers or external counsel. The driving reason behind this is a perceived short-term cost saving to the company. I say short-term because often such drafting leads to the creation of a pathological arbitration agreement, that is, an unenforceable arbitration agreement that ultimately leads the parties to spend more time and cost in figuring out the next steps. We have seen instances where the arbitration agreement refers to an institution that does not exist. Recently, we saw a reference in an arbitration agreement to the Contractors Arbitration Association in Ras Al Khaimah, which is non-existent. In such a case, a dispute arising under the agreement could likely be referred to court, which of course would be contrary to the parties' initial intention to arbitrate. Pathologies can also arise in preconditions to arbitration, which have the effect of taking the parties longer to commence the dispute. For example, a recent precondition to arbitration our client struggled with required the party to issue a notice of dissatisfaction on the engineer's failure to issue a determination before commencing arbitration. The engineer had no right to determine under the contract, so issuing a notice of dissatisfaction would be pointless. Your clause must also show a clear path to crystallizing your dispute. For example, we recently came across a design contract that states disputes are to be referred to a dispute committee before arbitration. Now, in such a situation, a party may refer a dispute in relation to delay to the dispute committee and may have another dispute arising in relation to cladding that, depending on the wording of the contract, may need to go through the same process. Therefore, you may be in a situation where you have one claim that is crystallized into a dispute and are waiting for another claim to crystallize to avoid filing separate arbitrations on separate issues. Choosing the seat of arbitration is not a decision to be taken lightly, particularly as the seat of the arbitration can affect the arbitral process in a number of ways. What you may consider to be a nice vacation spot could turn into a nasty seat for your dispute. You will want to ask yourself, what is the attitude of the national courts towards arbitration? Now, local courts can either be supportive or interventionist in their approach to arbitration. For example, in an arbitration seated in England, if the courts are to intervene, they will generally do so to support the arbitral process. You will also want to consider how an award can be challenged at the seat. The arbitration award can only be set aside or annulled in the courts of the seat of arbitration. Pro-arbitration jurisdictions tend to limit the party's ability to challenge an award, ensuring that the arbitration process remains as final as is possible. This is a priority for commercial parties. On this point, you should also be mindful of nuances that are unique to particular jurisdictions. For example, in the UAE, awards have been successfully challenged on the ground that the signatory to the arbitration agreement was not expressly authorized to sign. As highlighted by Anna in our first webinar, one of the major advantages of arbitration over domestic litigation is the regime for recognition and enforcement provided by the New York Convention. Parties should always try to select a seat in a country that is a signatory to the New York Convention to ensure recognition and enforceability of any award. You may wonder what, if anything, could possibly go wrong with specifying the number of arbitrators and the language of arbitration. You would be surprised. I will come to the number of arbitrators when we look at the different institutions. A point to note if you are going to set out the process for appointing arbitrators in your arbitration agreement is keep it simple. We recently saw an arbitration clause where the parties agreed that the arbitrator is to be nominated by each party within 42 days of the request of arbitration to commence arbitration submitted to the center. Now, we were representing the respondent. The arbitration was under the DAC rules, and the respondent wanted an additional 14 days to file the answer. This is not unusual, and it is permitted under the DAC rules. There was a confusion between the DAC rules and the parties' agreement. Ultimately, we advised the client to proceed under the arbitration agreement. This brings me back to my initial point. I cannot stress enough how important it is to have your lawyers involved in drafting your arbitration agreement to avoid your companies incurring additional costs further down the track when a dispute arises. It is also important to specify the language of arbitration to avoid a situation where an arbitration center decides the language for you and which may be unsuitable for the dispute and the parties. For example, under the Abu Dhabi Commercial Conciliation and Arbitration Center rules, the default language of arbitration is Arabic unless otherwise agreed by the parties. As Anna explained in our first webinar, a key drafting point of an arbitration agreement is to set out whether the arbitration will be institutional or ad hoc. Institutional arbitration is where a specialized institution intervenes and takes on the role of administering the arbitration process. Each institution has its own set of rules which provide a framework for the arbitration and its own form of administration to assist in the process. Now, there are approximately 1,200 arbitration centers worldwide for parties to choose from. Parties can choose an institution based on their location and where their transaction is taking place. For purposes of our session today, I will look at the institutions that we have seen most popular in international arbitration, that is the ICC, the International Chamber of Commerce, the LCIA, the London Court of International Arbitration, and closer to home, the DAC, the Dubai International Arbitration Center, and the DIFC LCIA arbitration rules. Now, before I look at the different institutions, let us consider ad hoc arbitration. Ad hoc arbitration is not administered by an institution. Parties have to determine all aspects of the arbitration themselves. For example, number of arbitrators, applicable law, and procedure for conducting the arbitration. Ad hoc arbitration has been seen in a negative light because it can get chaotic and more open to failure. as parties have to agree the process. However, it can be an efficient and an effective process if parties cooperate, which of course can be difficult given they are already in dispute. It can also be efficient and effective where you have a seasoned arbitrator who is able to control the process. For example, in an ad hoc arbitration, where we represented a developer, we successfully reduced their exposure to liability by 400 million dirhams. It did help that we had a senior QC as arbitrator, and his seniority helped guide the parties through the process and benefit from having an experienced person. Now, where parties are from different jurisdictions, that is civil law and common law, understandably, they will have different ideas about arbitration. In such cases, parties can choose to use the UNCITRAL arbitration rules. Now, a key advantage of institutional arbitration over ad hoc is precisely the involvement of an institution, because in case of an issue, the institution can support the arbitration. If an issue comes up in an ad hoc arbitration, it would need to be resolved through the national courts, which should be a comparatively lengthy process. For example, we represented a claimant in an arbitration where towards the end of the proceedings, the respondent asked the tribunal to extend the date to issue the final award because one of its witnesses had not given evidence during the hearing. Now, this was during the KSA purge, where a number of prominent businessmen had been detained, and it was speculated that this witness was one of them. The tribunal rejected the request because the greater injustice would have been to the claimant, as the proceedings had been going on for over 3 years and the witness was still unavailable. The respondent went to DIAC with the same request. DIAC supported the tribunal and reinstated the date for issuing the final award. Now, when we look at these different factors, we'll start off by looking at cost, and then we'll move on to look at duration, appointment and challenges of arbitrators, arbitrators' power to award costs, and review of the final award. So starting off with cost. The ICC is infamous for being the most expensive arbitration institution. Having said that, it has a reputation for being one of the best institutions, and this comes down to a number of factors, including the experience and qualifications of those who sit on the ICC court, and of course their scrutiny of final awards before they are issued. Under the ICC rules, an administration fee is payable at a percentage of the value of the dispute. The arbitrator's fees are calculated by reference to the time spent and the value of the dispute. An advance in cost is payable. In contrast, the LCIA is comparatively cheaper because administration fees are charged at an hourly rate. The arbitrator's fees are calculated by reference to time and hourly rates. An advance in cost is payable at the discretion of the LCIA court. Now, the DIFC LCIA rules are largely based on the LCIA rules and therefore follow a similar approach. Closer to home, and what we have seen as the most popular arbitration institution in the UAE, the DIAC, may be comparatively cheaper than both the ICC and the LCIA. The administration fee is based on a fixed percentage of the amount in dispute as per the DIAC table of fees and costs. The DIAC Executive Committee may adjust this either upwards or downwards because of the circumstances of the case. An advance in cost is required. A practical tip for you is it may be worth looking at the cost calculators that are available on websites of the different institutions to assess and compare the potential cost that might be involved should a dispute arise under your contract. Now, in our experience, on average, an arbitration can take from 12 to 24 months. The CIARB in a recent survey found that the average arbitration took between 17 and 20 months. So this is the kind of time frame that you should bear in mind. An arbitration under the ICC rules may take longer as the rules require the parties to agree a terms of reference and also allow for the award to be reviewed, which I will discuss later. Under the ICC rules, the time limit for rendering an award is 6 months from the date of signing the terms of reference, but this can be extended. Under the LCIA and the DIFC LCIA rules, the time for making of the award is as soon as reasonably possible following the parties' last submissions. Often parties will agree the date together with the arbitrator in their procedural timetable. Under the DIAC rules, the time limit within which the tribunal must render its award is 6 months from receipt of the file. The tribunal can extend this for an additional 6 months and a second additional 6 months by writing to the Executive Committee. Now, typically, most institutional rules provide for a sole arbitrator or a 3-member tribunal. You don't have even number of arbitrators because of the difficulty in decision-making. Where parties do not agree to a number of arbitrators in their arbitration agreement, institutions are inclined to go with a sole arbitrator unless the dispute warrants having 3. A key benefit of arbitration is the ability to choose your own arbitrator. So as a practical point, do set out the number of arbitrators in your arbitration agreement, so you have an opportunity to nominate your co-arbitrator should you wish to have a 3-member tribunal. The ICC, LCIA, DIFC LCIA, and DIAC follow similar approaches when it comes to appointing arbitrators. So I will not discuss the appointment process in detail. Things do get interesting with challenging arbitrators. Parties challenge arbitrators either for lack of impartiality or independence or both. Different institutions have different timeframes for raising challenges. Your lawyers need to be on top of these timeframes to avoid losing an opportunity to challenge an arbitrator. The ICC rules provide a 30-day window for a party to challenge an arbitrator. Ultimately, the ICC court is the one that decides on the challenge. Now, challenges to arbitrators under the ICC rules are rarely successful. The ICC courts will not hold back from finding a particular individual is suitable, as institutions want to maintain confidence in the process. For example, in 2014, 60 challenges were introduced against arbitrators, and out of these, the ICC only accepted 5. However, this is not to say that successful challenges cannot be raised against arbitrators. We successfully challenged the appointment of a party's nominated arbitrator in an ICC arbitration. The nominated arbitrator was a US lawyer who was previously a partner in the opposing counsel's firm. He was still receiving a pension from the firm at the time of his nomination. Yet, he did not consider this to be a conflict. This also shows that practitioners from different jurisdictions can have different approaches to conflict of interests. It is possible that an English QC in a similar situation would have refused appointment. In this case, the ICC court agreed with our challenge and did not proceed with the appointment. Therefore, you can raise challenges where you have carefully thought out and written arguments and you have facts that support these arguments. Now, under the LCIA rules, a party can challenge an arbitrator within 14 days of the formation of the arbitral tribunal or within 14 days of becoming aware of such grounds that may give rise to doubt as to the arbitrator's impartiality or independence. The LCIA court takes a similar approach to the ICC court. Institutions, of course, want to maintain confidence in the process. The LCIA has recently released an online database of its challenge decisions between 2010 and 2017. Interestingly, in the 1,600 cases that were registered with the LCIA during this period, the LCIA court heard challenges in less than 2% of these cases, and only 1/5 of those challenges were successful. In the most recent LCIA court decision, issued in 2017, a challenge was raised by the respondent to the appointment of a co-arbitrator on the basis that the arbitrator had represented a party and had a working relationship with the party's counsel over 17 years ago. The LCIA court rejected the challenge and decided that these are not circumstances that would give rise to justifiable doubts as to the arbitrator's impartiality or independence. This database is a useful tool introduced by the LCIA that your lawyers should consider before a party challenges an arbitrator to avoid raising frivolous challenges in an attempt to delay proceedings, which would not necessarily be in the best interests of the party raising them. Moving to the DIAC rules, a party can challenge the appointment of an arbitrator within 15 days of the formation of the arbitral tribunal, or within 15 days of the party becoming aware of any such circumstances. We have noted a high number of challenges to arbitrators in DIAC arbitrations. We have also found that the Executive Committee is not reluctant to find against a nomination. For example, we successfully challenged the appointment of an English QC because he had previously decided adversely against our client, and the DIAC accepted this challenge. Now, of course, having gone through the entire arbitration process, parties do want to know if they will get their costs. Under the ICC rules, LCIA, and the DIFC LCIA rules, an arbitral tribunal has the power and discretion to award costs to the parties. When I say costs, I mean the entire administrative fees costs, the arbitration costs, the legal costs, expert witness costs. All those costs fall under the umbrella. Now, when deciding costs, the arbitral tribunal will consider the conduct of the parties during the course of the arbitration and will consider instances where the parties did not cooperate and which caused delay to the proceedings. In contrast, the DIAC rules do not presently, in their current form, empower an arbitral tribunal to award legal costs of arbitration. But an arbitral tribunal can award administrative and arbitrator costs. So in the UAE, where you have a DIAC arbitration, it is recommended that parties agree for an arbitral tribunal to award legal costs in their arbitration agreement, as this becomes difficult to agree once the parties are in dispute. So it's wiser for you to put this down from the very outset in your arbitration agreement. There has been an update to the DAC rules, which expressly empowers a DAC tribunal to award party costs, that is, both legal representation fees and other party costs, such as expert fees and costs incurred through calling fact witnesses. However, these new rules are yet to come into effect by a ruler's decree. We are not aware as of now when they will come into effect, but we are watching for this development. Now, initially, I did mention this feature of ICC arbitrations, which is their scrutiny of final awards. Now, this is one of the most important functions of the ICC court in ICC arbitrations. It ensures that arbitral awards are of the highest possible standards and less susceptible to annulment. The ICC will make comments when they're looking at the final award during their review process. They'll make comments on, for example, where the tribunal neglected to decide on an issue, or where the tribunal decided on a point that was not raised by the parties. In fact, as you will see later on, these can be grounds to challenge the enforcement of an arbitral award. According to the ICC guide, it takes 2 to 3 weeks to review the draft final award. It can take longer, depending on the complexity and the length of the award. The other institutional rules, such as the LCIA, the DAC, and the DIFC LCIA, do not contain a similar mechanism for scrutinizing final awards. This does not necessarily put them at a disadvantage, because ultimately, a large driving force of a successful arbitration is having a good and competent arbitrator. Therefore, you should consult with your lawyers, find out the reputation of the particular individual in the market, and choose your arbitrators wisely. Now, I like to think choosing an arbitration institution is like choosing a pair of shoes. One size does not fit all. Parties involved in a multi-million transaction on an oil and gas project, for example, may prefer the ICC rules as opposed to the DAC rules, and may have the financial bandwidth to pay the cost of the ICC arbitration. On the other hand, parties to a construction contract for a residential tower may opt for the DAC rules because of cost and even familiarity if they are from the Middle East. Now, interim relief in arbitration is granted by the tribunal or by national courts and includes orders of attachment, injunction, or other provisional orders. Most institutional rules empower an arbitral tribunal to issue interim orders. For example, under the DAC rules, the tribunal may issue any provisional orders or take other interim or conservatory measures it deems necessary, including injunctions and measures for the conservation of goods, which form part of the subject matter in dispute. I will now briefly look at interim remedies in different jurisdictions such as the UK, UAE, and KSA. Now, it is common for parties to seek interim relief from the national courts, and this reinforces my earlier point on the importance of choosing the seat of arbitration. So let us first look at the UK. The English courts are constrained by the Arbitration Act of 1996 from intervening in arbitrations unless the tribunal cannot act, and then only to the extent necessary. If the arbitration is conducted under the London Court of International Arbitration Rules, for example, parties are able to access interim relief within the arbitral process and can appoint an emergency arbitrator or expedite formation of the tribunal to deal with urgent interim relief. The English courts are willing to intervene in situations where the tribunal lacks power. So, for example, where a tribunal has not been constituted and it would be too late to appoint an emergency arbitrator, or where the relief sought is against a third party who would be outside the tribunal's reach because it is not a party to the arbitration, or where an order of the tribunal would not be effective. In the UAE, the new arbitration law contains a non-exhaustive list of interim measures which can be issued by an arbitral tribunal, which typically includes orders to maintain evidence, assets or funds against which enforcement may later be sought, or to prevent a party from doing something that may prejudice the arbitration process, and to maintain or restore the status quo of the parties pending determination of the dispute. The tribunal's power to issue interim measures does not replace the court. Courts can grant interim measures under the new arbitration law. The most common interim measure we see parties seek in the UAE through the court is attachment of assets to avoid the threat of assets being dissipated. This is often sought under the UAE Civil Procedure Code before commencing an arbitration. Now, if a party is seeking this during the arbitration, it may prefer to seek an order of attachment from the tribunal because the tribunal is familiar with the case and the facts and may be able to issue such an order faster. A party with a successful order can then enforce this through the courts. In comparison to the jurisdictions I just discussed, arbitration in the KSA has not been a popular method of dispute resolution, primarily because of the court's intervention in the arbitral process and the uncertainty surrounding the enforcement of arbitral awards. However, there have been a couple of recent promising developments. In 2012, the KSA passed a new arbitration law and enforcement law. The Saudi Center for Commercial Arbitration was opened in 2016, complete with the publication of its arbitration rules. These are largely based on the UNCITRAL arbitration rules. Under the new KSA arbitration law, the parties can agree that the arbitral tribunal will have the power, at the request of one of the parties, to order any provisional or precautionary measures of protection as the arbitral tribunal deems fit. The law also contains possible sanctions if a party refuses to comply with the tribunal's order. Further, to the extent that the parties agree a set of arbitration rules, which provide for the tribunal to make orders relating to interim measures, these rules will be a further source of power for the tribunals to grant interim remedies. For example, granting an interim remedy such as security for costs. Now, it remains to be seen how the new arbitration and enforcement provisions will be applied in practice, and whether the judges will consistently apply the pro-arbitration laws that have recently been passed by the legislature. Again, I repeat the importance of choosing the right seat. The more sophisticated the seat, the better the probability of having supportive national courts rather than interventionist national courts. Now, the ease of recognition and enforcement of arbitration awards compared to court judgments in foreign courts is often seen as one of the key advantages to arbitration. Once you have successfully obtained an arbitration award, if the unsuccessful party does not voluntarily comply with it, you will need to take steps to enforce it. When enforcing an award, you could consider taking informal enforcement steps such as applying commercial pressure for the other party to comply with the award. This can be in the form of sometimes where certain trade bodies blacklist companies that have a substantial enforceable debt against them. Depending on the nature of the party's relationship, you could try applying diplomatic or reputational pressure to the unsuccessful party to push them to comply with the arbitration award. You could also try negotiating a reduction in payment, reflecting the costs saved by not pursuing formal enforcement proceedings. So you now have an award. You have tried informal enforcement, and the party is still not forthcoming. What then are your options? To enforce your award, you will look to the country where the other party has assets. In this scenario, guided by your lawyers, you will likely rely on the Worldwide Mutual Enforcement Treaty for Arbitration, that is, the New York Convention of Enforcement of Arbitral Awards. Under this convention, over 150 countries, including the UK, have agreed to enforce arbitration awards from other convention signatories in their jurisdictions as if they were local judgments, without having the need to review the substantive case. This is especially because some jurisdictions have particular rules which require the award to state certain things. This is why an important consideration when drafting your arbitration agreement is to check whether the country that you are choosing for your seat of arbitration is a signatory to the convention. This is because, provided that both the country in which the award was ordered and the country in which the enforcement will take place are signatories to the convention, and provided that the arbitration award meets the convention's basic requirements, that is, 1, it is in writing, and 2, it is signed, the award in such an instance will be recognized as binding and can be enforced by the party in any other signatory state with the assistance of the local courts. Now, you should be wary of the limited grounds on which the local court may refuse to recognize and enforce the award. Under the convention, an award may not be challenged on its merits, but may be challenged on grounds such as incapacity of the parties or invalidity of the agreement, failure to give proper notice of the appointment of the arbitrator or the arbitration. That is, a party may argue that they were denied a fair hearing, or where an award refers to an issue not submitted to the arbitration. That is, the arbitral tribunal exceeded its authority or lacks jurisdiction. Another ground to challenge could be composition of the arbitral tribunal or the procedure was not in accordance with the parties or applicable law. That is, there was some sort of procedural irregularity. Another ground to challenge could be the award is not binding or has been set aside or suspended. That is, you have an invalid award. Finally, the Convention provides that another ground to challenge could be the subject matter of the dispute is not capable of being resolved through arbitration or public policy of the enforcing state. Now, a consequence of enforcement is attachment of the unsuccessful party's assets. To give you an example, during the recognition and enforcement proceedings of an award rendered against Thailand under the Germany-Thailand Bilateral Investment Treaty, the Crown Prince of Thailand landed his private jet plane at a German airport. The plane was attached as security by the German creditor on the plane landing. Now, I would have been severely disappointed if that were my plane. The plane was released after Thailand provided the creditor with a bank guarantee issued by a German bank as security covering the amount of the award plus costs. Now, despite all the promise of the Convention, it can be a difficult, costly, and lengthy process to enforce an award. This has led to some organizations offering an innovative insurance policy known as an arbitration default insurance. A party hoping to be successful in an arbitration can obtain the insurance before an award is issued. On the issuance of a successful award, the insurance company pays a certain percentage of the awarded amount and continues to recover the entire amount through enforcement of the award. In an ICC arbitration where we were acting for the Tanzanian government, our client paid an insurance premium of $4 million for such an insurance policy. Our client received a successful award of $60 million, out of which it received an advance payout from the insurance company of $48 million. So obviously, one can see the benefit of getting this kind of insurance. Now, notwithstanding its practical and monetary usefulness to a party, this type of insurance has not gained as much traction or popularity as third-party funding. If you would like to know further details about this type of insurance, please do contact us. Right. The key to having a successful arbitration all starts with parties agreeing to a robust arbitration agreement carefully drafted by your lawyers. Your legal advisors should advise you on your arbitration agreement based on the particularities of your transaction and agreement. Factors such as those that we have discussed in our webinar series should be taken into careful consideration. A well-known advantage of arbitration over litigation is its speed. To gain benefit of this advantage, parties must start by getting their arbitration agreement right. In addition, during the arbitration process, there are tools available to you as a party to protect your interests, to ensure a party does not abuse your rights, and to pave the way for achieving a solid final award that can then be successfully enforced. Now, this is not to say that you should go into an arbitration all rosy eyes and bushy-tailed, but instead, parties should be alert and in discussion with their lawyers throughout the arbitration to achieve the best possible outcome. I hope you have found our webinar series useful. There is a lot involved in achieving an efficient arbitration. I look forward to receiving your questions, comments, and any feedback on this webinar.